The camera moved when Elena stepped out of her bedroom. That was the detail that made her call me. Not the fact that her neighbor had installed security cameras. Plenty of people had cameras. Most families on her street in Calabasas had doorbell cameras, garage cameras, and small units pointed toward their driveways. The problem was that this one did not watch a driveway. It watched her. Elena had noticed it on a Sunday afternoon. She was folding laundry in the upstairs bedroom when she opened the curtains to let in some light. Across the narrow gap between the homes, mounted beneath the eaves of her neighbor's second-story roofline, was a black dome camera. At first, she assumed it was aimed toward the side gate. Then she saw it turn. The camera pivoted away from the gate, tracked across the backyard, and stopped directly on her bedroom window. She froze. A second later, it moved again, downward, toward the pool. Elena closed the curtains, walked downstairs, and called her husband. Her husband, Mateo, was working an afternoon shift at an aerospace company in Woodland Hills. He told her not to panic. He told her they would talk to the neighbor when he got home. But by the time Mateo came home, the camera had become one part of a much larger problem. There were 4 of them. One above the neighbor's garage, facing the street. One above his side gate, facing the walkway. One at the rear corner of his house, angled across Elena's pool deck. And one mounted high under the second-story eaves, with a clear view of the upstairs bedroom windows and the small wooden play set where Elena's 2 children spent most afternoons. Elena called me 3 days later. When I arrived, she was waiting beside the pool with a legal pad in her hand. She was 38, worked in human resources, and had the controlled, exhausted expression of someone who had spent several days telling herself she might be overreacting. "I don't want to be one of those neighbors," she said. "What kind of neighbor?" "The kind who complains because somebody installed a camera." "I don't hear you complaining about a camera," I said. "I hear you describing where it points." She nodded. "That's what I keep trying to explain." Her backyard was enclosed by a 6-foot stucco wall. With a narrow strip of landscaping between the homes, the pool sat at the center of the yard. To one side was a covered patio with a dining table. On the other side stood a wooden swing set with a small slide and climbing wall. The camera on the neighbor's rear eave had been installed high enough to see over the wall. It faced directly into the yard. I stood near the pool and looked up. The camera was not subtle. It was a motorized pan-tilt zoom model, larger than a standard home security unit, mounted to a metal bracket. It had a small blue status light beneath the lens. Even from the ground, I could see the lens shift. Elena saw it too. "There," she said. The camera moved slowly toward the pool. Then it stopped. "You saw that?" she asked. "Yes. I have video." "Show me." She opened a folder on her phone. For 5 days, Elena had recorded short clips from different places in her yard. One showed the camera pointing toward the play set at 3:41 p.m. Another showed it facing the upstairs windows at 8 to 12 p.m. A third captured the camera rotating as Mateo cleaned leaves from the pool. The clearest video had been taken 2 nights earlier. Elena had turned on the backyard lights after the children were asleep. She stood near the patio and pointed her phone toward the neighbor's roofline. The camera lens turned toward her, held still for several seconds, then tilted downward until it centered on the sliding glass door to the master bedroom. I watched the clip twice. "Did you speak to him?" I asked. "Mateo did." "What did he say?" Elena looked toward the neighboring house. The owner was named Travis Harlan. He was 44, divorced, worked in private security consulting, and had moved into the home 8 months earlier. The first few months had been uneventful. He kept to himself. He drove a dark SUV. He had contractors coming and going as he renovated the interior. Then the cameras appeared. Mateo had gone next door last Friday evening. He introduced himself, said the cameras seemed to face their backyard, and asked whether Travis could adjust them. According to Elena, Travis did not deny the cameras were aimed over the wall. He said he had installed them because people around here have too much to hide. Mateo told him that their children use the backyard every day. Travis leaned against the doorway and said, "If you don't have anything to hide, why are you scared of a camera?" Elena repeated the line exactly. Then she added, "He said the cameras were on his house, so he could point them wherever he wanted." Did Mateo record the conversation? No. Any witnesses? Our daughter was inside by the window. She heard him. But she's 9. I don't want to pull her into this. You don't have to. I looked again at the camera above the roofline. Did he ever tell you there had been a theft or a security incident? No. Has anything happened on this street? Not that we know of. Did he report concerns to the HOA? I checked. The board said he never did. That mattered. A reasonable person may install cameras for security. A reasonable camera points toward entrances, vehicles, gates, or the owner's own yard. But when a camera tracks a neighbor's bedroom window, pool area, and children's play set, the question changes. It is no longer just about where the device is mounted. It is about what the device is designed to observe. I asked Elena whether the cameras had visible warning signs. None. Can you see whether they record audio? I don't know. Can you hear any speaker or microphone? Not from here. Do you have a second-floor view from inside? Yes. We went upstairs. From the children's bedroom, I could see the rear camera clearly through the side window. The lens had a broad arc over the wall and into the pool area. From the main bedroom, the second-story camera sat almost level with Elena's window. I took photographs from both rooms. Then I used a simple test. Elena stood at the pool gate while I watched the camera through the upstairs window. When she walked toward the patio, the camera shifted. When she moved toward the play set, it shifted again. I did not know whether the device was manually operated, set to motion tracking, or controlled by an automated routine, but I knew its view was not fixed on Travis's property. It was following movement inside Elena's yard. That afternoon, I checked the community's architectural rules. The HOA had a section on exterior security devices. It allowed cameras for reasonable residential security purposes, but prohibited equipment that created a nuisance, violated another resident's reasonable expectation of privacy, or captured areas beyond the owner's property without legitimate necessity. The rule was vague, but it was useful. Then I checked the City of Calabasas municipal code and public privacy guidance. I was not looking for a magical sentence that said no camera may ever see another person's yard. Laws were rarely that simple. I was looking for rules about surveillance equipment, recording, nuisance conduite, and especially audio capture. California had strict rules around confidential communications. If Travis's system recorded conversations from Elena's patio, he could have a very different problem from a camera pointed at a driveway. I did not assume it recorded audio. I planned to find out. The next day, I sent Travis a written notice. It was not threatening. It stated that Elena and Mateo had observed multiple cameras directed into their private backyard, pool area, upstairs bedroom windows, and children's play area. It requested that he preserve all existing footage and configuration records, stop any recording of areas beyond his property, and provide confirmation that the cameras had been re-aimed within 48 hours. I also asked whether his system captured audio. He replied 4 hours later, "Travis, my cameras are lawful security devices installed on my own home. I will not disable or reposition them because your clients are uncomfortable. I do not discuss my security protocols with neighbors." Then came a second message. "Travis, if they are concerned about being observed, they should build a taller wall." Elena read the messages in silence. Her children were at school. The pool was still. Across the wall, the blue light beneath the camera lens blinked once. Then again. "He thinks he can do anything because it's his roof," she said. "Maybe he thinks that." I said, "Can he? No one can use their property in a way that ignores everyone else's privacy." At 4:20 that afternoon, Elena's daughter, Sophia, came home from school. She ran outside with her backpack still on and climbed onto the playset. She had barely reached the top platform when the rear camera moved. It turned toward her, Then it tilted down. Elena stopped breathing. I was standing beside her. I watched the lens settle over the play area, and I knew the next part of this case could no longer be handled as a private disagreement between two neighbors. Because Travis Harlan had not simply installed cameras to protect his home, he had pointed them at a place where children were meant to feel safe. The camera stayed on Sophia for 11 minutes. I timed it. Not because I thought the exact number would somehow make the situation more disturbing. It already was. But details matter. When someone later says a device only moved for a second, only caught an angle by accident, or only responded to motion from a shared boundary. At 4:12 m. Sophia climbed onto the playset. At 4:21. The rear camera rotated toward her. At 4:23. It adjusted downward. At 4:31. Elena called Sophia inside. At 4:32. The camera remained pointed at the empty slide. At 4:34. It finally turned back toward Travis's side yard. I wrote every time down. Then I asked Elena and Matteo to stop confronting Travis directly. They had already given him a fair chance to change the angles. He had responded in writing. There was nothing to gain from another conversation across a front porch. The next day, I returned with a photographer named Jordan Lee. Jordan did not photograph people. He photographed sightlines. From Elena's second-floor bedroom, he captured the exact angle of the camera lens in relation to the window. From the pool deck, he photographed the rear device above the wall. From the playset, he documented the line from the camera to the climbing platform. Then he used a laser measure to record the distance between the devices and the areas they could see. The goal was not to create a dramatic video. It was to establish something simple. The cameras were capable of observing Elena's private yard, not by chance. By design. Jordan also used a telephoto lens to identify the model number printed along the underside of the upper camera housing. It was a Sentinel Petit Set X4. When I looked up the manufacturer's product information, I found exactly what I expected. The model included pan, tilt, zoom, motion tracking, infrared night vision, cloud recording, and two-way audio. That did not prove Travis had activated every feature, but it proved the device was built to track movement and capture audio, and that meant we had to treat the situation carefully. Elena and Matteo did not start shouting toward the camera. They did not test whether Travis could hear them by discussing private things in the yard. They did not try to access his system. They did not point lasers at the lens or damage the device. They did what reasonable people do when they suspect a boundary has been crossed. They documented it. On Friday morning, Matteo received a call from his sister. She had been visiting 2 days earlier. Sitting beside the pool with Elena while the children played, she remembered hearing a short electronic chime from the camera mounted over Travis's rear eave. I thought it was some kind of alarm, she told Matteo. But then there was a sound like someone clearing their throat. Did you hear words? He asked. No, just the sound. That was not proof of recorded audio, but it was enough to make the question more urgent. I contacted a local attorney who handled property and privacy disputes. Her name was Priya Shah. I sent her the photographs, the camera model information, Travis's written responses, the HOA rule, and the timeline of the camera movements. She read everything before calling me. You've done this correctly, she said. What do you think? I think the HOA needs to open a formal enforcement review. I also think Travis needs to preserve the footage and configuration data immediately. Do we have enough? We have enough to demand a response. Whether it becomes a civil claim depends on what he recorded, how he used it, and whether audio was captured. Priya sent a preservation notice to Travis that afternoon. The notice did not accuse him of committing a crime. It informed him that a dispute had arisen concerning surveillance directed into a neighboring residence and private backyard. It instructed him not to delete, alter, overwrite, or conceal camera footage, audio files, settings, user logs, cloud backups, or device configurations relevant to the cameras. Then it made 3 requests. First, Re-aim the cameras, so they monitored only his property and lawful points of entry. Second, disable any audio capture that could record conversations from Elena's yard. Third, provide written confirmation of the changes. Travis had 5 business days to respond. At the same time, Elena filed an architectural violation complaint with the HOA. She attached the sightline photographs. She attached Travis's messages. She attached the community rules stating that exterior security devices could not invade a neighbor's reasonable expectation of privacy without legitimate necessity. The HOA had no excuse to ignore it. The board scheduled a hearing for the following week. Travis responded the night before the hearing. His email was only 2 paragraphs. He said the cameras were necessary because he had observed suspicious conduct near his property. He claimed that guests from Elena's home had entered the side setback between the houses and that he had reason to believe the family had interfered with his landscaping. He offered no dates, no photographs, no police report, no damaged property, no prior complaint to the HOA. Then he made an accusation that sounded designed to turn the situation around. He said Mateo had acted aggressively during their first conversation and that the camera coverage was needed for Travis's personal safety. Elena read the email at the kitchen table. Mateo was beside her. "Did you ever threaten him?" I asked. "No." Mateo said. "Did you raise your voice?" "No." "Did you step onto his property?" "No." "I stayed on the sidewalk." "Did you ask him to adjust the cameras?" "Yes." "What did he say?" Mateo looked down. "He said if we didn't have anything to hide, we wouldn't care." "Did you tell him he could not have cameras?" "No. I told him not to point them into our bedroom and at our kids." The hearing took place on a Wednesday evening in the small HOA conference room. The board consisted of 5 homeowners. None of them were lawyers. None of them wanted to become the center of a privacy dispute between 2 neighbors. But they were responsible for enforcing the rules they had adopted. And for once, they seemed to understand that saying, "We don't want to get involved," was not a solution. Travis arrived with a printed binder. Elena and Mateo arrived with Priya. I sat beside them with the sightline photographs and the timeline. The board president, a woman named Sherry Dalton, opened the hearing. "This is not a criminal proceeding," she said. "We are here to determine whether any exterior equipment violates the association's architectural and nuisance rules." Travis nodded. Then he began explaining his security system. He said he had experienced theft in a previous neighborhood. He said he worked with clients who expected discretion. He said the side setback between the homes was narrow and difficult to monitor. He said the cameras were motion activated and intended to protect his property. Priya waited until he finished. Then she placed the first photograph on the table. It showed the rear camera centered on Elena's playset. "This is not Mr. Harlan's side setback," she said. The second photograph showed the upstairs camera aligned with the master bedroom window. "This is not Mr. Harlan's gate." The third showed the camera's recorded angle toward the pool deck. "This is not a shared access route." Travis crossed his arms. "Those are still views from my home. Of areas where your neighbors have a reasonable expectation of privacy," Priya said. The board president looked at the photographs. "Mr. Harlan, can these cameras be masked or limited to your property?" "They can," he said. "Have you done that?" "No." "Why not?" "Because I should not have to compromise my security due to their discomfort." That was the moment the board stopped seeing the dispute as 2 people with different preferences. The camera could be re-aimed, the system could use privacy masking, the audio could be disabled. Travis had been offered a reasonable solution before anyone filed a complaint. He had refused not because he could not protect his home another way. He had refused because he wanted the ability to watch Elena's home. Then Priya asked the question we had been waiting to ask. "Does your system record audio?" Travis looked at her. "I don't have to answer technical questions about my security setup." "You do not have to answer voluntarily," Priya replied. "But the preservation notice requires you not to delete or alter relevant configuration information." The room went quiet. Sherry looked at Travis. "Does it record audio?" He shifted in his chair. "I believe the feature is disabled." "You believe?" "I don't use it." That is not the same answer, Priya said. Travis's attorney was not there. His private security consultant confidence had suddenly become much less useful in a room where every word could be written down. The HOA board did not make a final decision that night. It requested a written statement from Travis confirming the camera settings, including whether audio capability had been activated. It also ordered him not to change or delete any recordings while the review continued. Then the board issued a temporary directive. The rear camera and the upper camera had to be repositioned within 72 hours so they did not capture Elena's pool, playset, patio, or bedroom windows. Travis left the meeting without speaking to anyone. For the first time in weeks, Elena felt like the situation might finally change. Then, at 10:18 the next morning, she received a notification from her own doorbell camera. Travis had entered his backyard carrying a ladder. He stood beneath the rear camera. He reached up, and instead of turning it away from Elena's yard, he removed the device entirely. At first, that seemed like progress. Then he carried it inside. By noon, the camera was gone from the exterior wall. But that night, Elena noticed a faint blue light glowing from an upstairs window in Travis's house. The camera had not been removed. It had been moved, and from behind the glass, its lens now pointed directly through the narrow gap between the homes toward the children's playset. Elena did not go into her backyard that night. She closed the curtains in the children's room. Mateo checked the locks twice. Sophia asked why the patio lights were off, and Elena told her they were giving the garden a rest. It was not a lie, but it was not the truth either. The truth was that a family who had bought a home with a pool, a patio, and a small wooden playset no longer felt comfortable using any of them. The next morning, Elena sent me a screenshot from her doorbell camera. At 7:16 am. Travis had opened the upstairs window. The blue light inside his room was visible through the glass. At 7:21, the light disappeared. At 7:29, it came back on. The timing was not enough to prove he was watching anyone, but it showed the device had been moved after the HOA issued its temporary directive. Not disabled, not re-aim, moved indoors. Priya filed a request for emergency relief that afternoon. She did not ask a court to ban Travis from owning cameras. She did not ask anyone to enter his home or seize his equipment. The request was narrow. It asked the court to order Travis not to direct surveillance equipment toward Elena's private backyard, bedroom windows, pool area, or children's play area. It asked him to preserve relevant footage and device settings, and it asked for a neutral technical review of the camera configuration, limited only to determining the direction, recording settings, audio settings, and stored footage relevant to the dispute. That distinction mattered. The issue was not that Travis wanted security. The issue was that he had refused every reasonable way to secure his own home without observing someone else's private life. The court scheduled a hearing within days. That was enough to change his position. Travis hired an attorney. His attorney contacted Priya before the hearing and said Travis was willing to discuss a resolution. He continued to deny wrongdoing. He continued to claim that his cameras were installed for security purposes, but he was no longer saying he could point them wherever he wanted. Priya and I met Elena and Mateo at her house to explain the proposal. The first offer required Travis to remove the exterior cameras facing their yard and apply privacy masking to the remaining devices. It did not mention the upstairs camera. It did not mention audio. It did not mention stored footage. Elena read the offer, then placed it on the table. "No," she said. Priya looked at her. "No?" "No," Elena repeated. "He doesn't get to say he'll adjust the outside cameras when he already moved one inside. And I want to know whether he has recordings of my children in the backyard." It was the first time Elena had spoken with no hesitation at all. Not angry. Not loud. Just clear. Priya nodded. "That is reasonable." The second proposal was much stronger. Travis would permanently remove the upper exterior camera and the rear pan-tilt camera. The remaining cameras would be fixed-angle devices aimed only at his driveway, front walk, garage, and side gate. A neutral technology specialist would inspect the surviving system in his presence and confirm that all cameras had privacy masking enabled for Elena's property. Audio recording would be disabled. Any stored footage showing Elena's backyard, pool, patio, bedroom windows, or children's play area would be identified, preserved for the limited purpose of the dispute, and then deleted under the neutral specialist's written certification. Travis would not use, distribute, share, or retain any recordings that captured Elena's private property, and he would pay a portion of Elena and Mateo's legal costs. His attorney asked for time to consider it. The answer came the next morning. Travis agreed, not because he suddenly understood why the family had felt violated, not because he apologized. He agreed because the evidence had left him very little room to keep pretending the cameras were ordinary security devices. The neutral specialist arrived the following week. His name was David Eng. He had no connection to either household. He did not search Travis's personal files, emails, or private documents. He inspected only the security system hardware, the connected application dashboard, and the cloud storage linked to the 4 cameras. Travis and his attorney were present. Priya attended for Elena and Mateo. I waited outside with Elena near the pool. Neither of us wanted to see the inside of Travis's house. That was not the goal. The goal was to make the boundary clear. About an hour later, David came out with both attorneys. He did not discuss private details in the driveway. He simply confirmed that the system had been configured to record video and audio from the installed cameras. Elena looked at Priya. Audio? Priya nodded once. David explained that the system's audio feature had been active when the cameras were first installed. It had later been disabled on 2 cameras, but the rear camera had recorded audio until the week after the HOA hearing. The stored footage included clips from Elena's backyard. Some were motion-triggered. Some were longer recordings created when the camera tracking feature followed movement. David did not describe the contents beyond that. He did not need to. The fact that the footage existed was enough. Travis's attorney asked whether the issue could be resolved without further court proceedings. Priya said yes, but the settlement would need to include everything already proposed, plus a written acknowledgement that Travis had retained recordings from outside his own property, and that those recordings would be deleted under independent supervision. The final agreement was signed 2 days later. Travis did not admit to a crime. He did not make a public apology, but he agreed to terms that mattered more than a speech. The 2 cameras with a view into Elena's yard were removed. The upstairs window camera was removed. The remaining exterior devices were replaced with fixed-angle cameras aimed at Travis's own entrances and vehicles. Privacy masks were programmed over Elena's backyard and windows. Audio capture was disabled across the system. All relevant stored footage was reviewed only to identify material covered by the agreement, then deleted with a written certification from the neutral specialist. Travis paid $11 and $500 toward Elena and Mateo's legal and technical costs. The HOA also issued a formal violation notice. The board updated its security device rule so that all cameras visible from the exterior had to be submitted for architectural review. Pan-tilt zoom cameras could not be directed toward neighboring yards, windows, pools, or play areas. Any device with audio capability had to comply with applicable privacy rules, and residents were required to use privacy masking when a camera could view beyond their own property. The new rule did not ban security. It made security reasonable. A month later, the backyard looked normal again. The pool water caught the afternoon light. The children's playset had been repainted because Sophia said the old blue color reminded her of the watching light. Mateo replaced it with a warm sunflower yellow. Elena stood beside the patio table while her children played. For the first few minutes, she kept looking toward Travis's house. The old camera brackets were still visible beneath the eaves. Small dark marks against the stucco. But there were no blue lights. No moving lenses. No silent turns toward the pool. Sophia climbed the ladder to the platform and waved at her mother. "Can I stay outside until dinner?" she asked. Elena looked up at the open sky over the yard. "Yes," she said. "You can?" Later, When the children had gone inside, Elena sat beside me with 2 glasses of iced tea. I kept thinking I had to prove he was a bad person. She said, "You didn't. I thought that was the only way anyone would listen. You only had to prove what the cameras were doing." She considered that. Does that really make a difference? It makes all the difference. People often think privacy is about secrets. It is not. Privacy is about having a place where you are not performing for someone else. A place where your children can play without wondering who is watching. A place where you can open your curtains, sit by your pool, or speak to your family without feeling like your own home has become part of another person's security feed. Travis had said that people with nothing to hide should not fear cameras. But that was never the point. A home is not a place where you have to prove you deserve privacy. It is the place where privacy should begin. If your neighbor's cameras were aimed at your pool, bedroom windows, or children's play area, what would you do first? Share your answer in the comments. Subscribe to Anna's Neighborhood Justice for HOA drama, neighborhood privacy disputes, and property conflicts, where clear evidence changes everything.